Welcome back to Civics, Episode 7, and today we'll talk about Article 3 of the Constitution, which details the judiciary branch. And we'll talk a little bit more about what the judiciary branch is now able to do because of some changes that have happened over the course of our history. So to get started, the Constitution really only explicitly calls that there be one Supreme Court. Now, does it say that the Supreme Court has to have 9 justices? Nope. It just says there has to be a Supreme Court. Originally, the court only had, I think, 5 justices on it. So the court number has changed, and the body of government that has the choice over what to do with that court is Congress. So Congress is allowed to change the size of the Supreme Court. Congress is allowed to establish as many other federal courts as there needs to be. Now there's tons of federal courts. There's appeals courts, and there's regular federal courts. Those are all created by Congress, and Congress controls those courts. So the judiciary branch is checked by Congress, and it is also checked a little bit by the executive branch because members of the Supreme Court are appointed by the president. Okay. Currently, there are 9 justices on the Supreme. Well, actually, that's not true. Currently, there are 8 justices on the Supreme Court. At the time of this video, we're about a week after Ruth Bader Ginsburg died, which was tragedy. She was a great justice. And currently, the president has nominated a new justice to take her place. So currently there's 8 justices. Soon there may be 9. It depends on if the vote actually happens or not, or I'm sure it's going to happen, but if it actually goes through, it's kind of a mess right now. We'll have to find out what happens. So that'll be a fun real-time civics lesson right there. So the Supreme Court has jurisdiction over certain cases. Those cases are about laws that are passed by the federal government, so they have jurisdiction in federal cases. They have jurisdiction over anything that has to do with an ambassador. So if an ambassador does something wrong, the Supreme Court is the one that tries that trial. If the U.S. is a party in the case, so let's say somebody sues the American government, or the American government is suing someone else, the Supreme Court then is the person who has to hear the body that hears that case. And then any case that involves 2 or more states. So let's say like Massachusetts sues New York for whatever reason. That would be a case that the Supreme Court would see, not another court. So they have very specific cases that they try. In the Article 3, it does say that juries are required in all federal cases. The Supreme Court is kind of established as the final appeals court. So if something works its way through the system and it gets to the Supreme Court, what the Supreme Court says is what happens. It's the final level of appeals. So the Supreme Court decision is final. Now, something that's not in the Constitution that gets established afterwards, because Article 3 is actually not that very long. There's not a whole lot in there. In a Supreme Court case that happens, I believe, in 1803 or 1804. Hold on. I have it written down. Or I did. Whatever. All right. So I did have it written down, but I have seemed to lost. Yep, I don't know where it is. Regardless, the case is called Marbury versus Madison, and it was about John Madison not allowing a bureaucratic member of the State Department take his place because he was appointed by John Adams. So John Adams appointed this person at the end of his presidency. He had lost the election, and so he decided to fill as many federal offices with people he liked as possible. And so when this guy showed up, because he was like, hey, John Adams gave me this job, James Madison, who was the new Secretary of State under the new president, Thomas Jefferson, was like, yeah, we don't want you here, bye. And so Marbury sued, and the case ended up going all the way to the Supreme Court. And John Marshall, who was the head justice at the time, wrote the decision, and basically he said, look, 1, the president is allowed to change the bureaucracy whenever he wants. So if he doesn't want you to be a member of the State Department, then you're not going to be a member of the State Department. He can choose somebody else. So Marbury lost his case. But then John Marshall went on to say afterwards that the Supreme Court, it has a duty and a job to declare laws unconstitutional. So basically he says, this is kind of a paraphrase, but he says, the court can declare laws unconstitutional and strike down laws if they don't fit into the constitutional bounds. And he says this because it's necessary to strike down bad laws, and that's because of the oath the justices take when they become a Supreme Court justice. So when the Supreme Court justice becomes a justice, they take an oath to defend the Constitution. And so John Marshall basically says that it's within our power as the Supreme Court, because of the oath we took, to strike down bad laws that are not within the framework of the Constitution, so that we can protect the government and the Constitution. That concept is called judicial review. And so that's not a power that the Supreme Court is originally supposed to have. It's not written in the Constitution, but it's something that we've come to accept as a de facto power that the Supreme Court has. So the Supreme Court basically said, we have to have this because of our oath, and our government has generally accepted that as the truth, right? If the Supreme Court thinks something's unconstitutional and they have a legal reasoning as to why, they can strike down those laws. Now, how many times has this been used? By 2014, 176 different statutes and laws have been ruled unconstitutional. So it does happen. Does it happen often? No, but it does happen. And judicial review is also a way for the Supreme Court to kind of set precedent in the law. For example, a famous court case called the Miranda case made it so that police officers have to say your rights when you get arrested. That's because of a court case, not necessarily because of a law that was written. Now, it's been codified since then, but before that, that Supreme Court case is what created that legal definition of what your Miranda rights are, and that you have to have them said to you. Same thing with the Supreme Court case Roe versus Wade, or Brown versus the Board of Education. All those things aren't necessarily the Supreme Court striking down a specific law, but they are saying that, look, if you do something along these lines, it's not constitutional and shouldn't be done. So those Supreme Court cases hold weight and have caused changes in American society, and that's also part of judicial review. So that's basically the general gist of the judiciary branch. And in the next episode we're going to talk about the other articles in the Constitution and what they do and what they mean. And then we'll move on to the other parts of the Constitution, which are the amendments, so the things that have changed since the Constitution was written. Thanks for watching again. Can't wait to see you next time. Have a great day.